If a person gets charged with a crime, a lot of times they don't realize the cost of litigation or the benefit, the upside and the downside of litigation. And we really see that in this news article right here that is published in Law and Crime. And this is an article by Colin Kalmbacher. It was published on April the 9th, 7:16 p.m. And I'm going to turn to this in just a moment because there has been some interesting developments in the Lori Loughlin case about exculpatory evidence. Now, if you read this article right here, you will see that the defense attorneys that are representing Lori Loughlin and her husband, Massimo Giannuelli, I don't even know how to pronounce his name. These people have been in the news for more than a year regarding this case that prosecutors in Boston brought against individuals who theoretically bribed Rick Singer or provided resources to Rick Singer, a government informant, to get their children into prestigious universities. It's been published all over the media. My partner Justin Paperny has commented a lot on it. But most of the people have chosen not to go to trial. They have chosen to take a plea agreement from prosecutors to avoid the danger of a very long prison sentence. And that is generally what happens to people who get charged with a crime. Courageously, this group, who of course has enormous financial resources, chose to litigate. They had the courage to say, I don't care what the prosecutors say. I did not knowingly bribe anyone. And because they had extensive resources, they could hire the best defense attorneys that would help them bring the case. And you can see what has happened today, and this is today's article, and I'm publishing this on April the 18th, 2020. It's now about 9 o'clock in the morning on a Saturday, and I saw this headline, Judge Calls for Alleged Investigator Misconduct in Lori Loughlin Case. He calls it serious and disturbing. And so we want to talk a little bit about what government or prosecutorial misconduct is, and it would be if the prosecutors have evidence that would tend to exonerate a defendant, they have a responsibility and a duty to present that evidence to the defendant. And the defendant then could use that in their defense. That's what goes on through the discovery process. Now, prosecutors theoretically should have provided that discovery to the defense team at the very start of the case. This is months ago, but they didn't. They withheld it. And as a result of them withholding it, the defendant was in a very weak position. She had the courage to say, I know I didn't do anything wrong, and I'm going to fight this and let a jury of my peers make a determination of the truth. That is the cost of going to trial. And it was because they could afford to finance the lawyers to continue pressuring the prosecutors, they eventually got this evidence, which really tends to it caused the judge to say he may dismiss the case. My expectations are I don't know one thing or the other of what the judge is going to do. What I know is that they are playing a very high-risk game that could expose them to a very long sentence, and I've got tremendous respect for them for the courage that they have in fighting the prosecutors, because the prosecutors can be bullies. They can bully somebody by threatening to indict their wife, by threatening them to increase the amount of loss, by threatening them to bring superseding indictments that expose them to longer periods of time in prison. And they could do this all the while knowing that there is evidence in their case that could tend to exonerate the defendant. And the defendant didn't know it. So it took many months of litigation. I have no doubt that many millions of dollars in legal expenses. But look what they received, this jewel of information that results in the judge making an order. Says the court considers the allegations in Singer's October notes to be serious and disturbing. That's what the judge wrote. While the government agents are permitted to coach cooperating witnesses during the course of an investigation, they are not permitted to suborn the commission of a crime. And the judge so far has not made a determination on whether to dismiss the case. They've given the prosecutors until May the 1st to respond to the government. But we have learned now in the media here, what are in those notes that Singer took in October? He wrote in one note that the FBI officials got loud and abrasive, and they continued to ask me to tell a fib about what he told clients before they paid him to be in his scheme. So what's going on here? we've got Singer, who has already admitted to bribing officials. But when he was bribing them, he has said that previously he did not tell his clients that he was bribing them. He presented an opportunity for them to use his coaching skills, and he charged a substantial fee to provide those coaching skills. But maybe he didn't tell them that he was bribing people. Now, the prosecutor is saying that he did tell them that. And if he did that, well, then they would be guilty of this conspiracy, this bribery conspiracy that could expose them to a lot of time in prison. Many of the defendants, rather than facing the huge risk of a trial, they have chosen to plead guilty and said, let me just move on, put this in my past. I'm going to plead guilty. And as a result of that plea agreement, they got 15 days or maybe a few months in prison. Whereas Lori and her husband, Massimo, have said, no, we're going to litigate. I don't care what it costs. I didn't do anything wrong, and I'm going to fight. There's a huge risk to that. And that risk is that if they are convicted after a trial, they will receive a significantly longer sentence. That's not a maybe, that's a fact. They will not get 3 points for acceptance of responsibility under the federal sentencing guidelines. The probation officers will say that they were recalcitrant and non-remorseful. The prosecutors will really tarnish their reputations, as they've been doing for the past year, and as prosecutors are wont to do. Why is that? It's because the government will do whatever it takes to win a case. They're not necessarily after justice, they are after a conviction. And the more we understand that, the better we, as individuals who are confronting a problem with the criminal justice system, the more powerful we become to make good decisions. Do I want to litigate? Do I want to take a plea agreement? What are my resources? Do I have the resources of this family that likely spent millions of dollars to get to this point so they could get this evidence? Well, we don't know what's going to happen with this evidence. We don't know if the judge is going to dismiss the case or if he's going to admit it to the jury when they go to trial. But what we do know is that prosecutors withheld exculpatory evidence. In fact, I think it says here that they have apologized for prosecutors admit the error in Lori Loughlin's case after whistleblowing key evidence, after withholding key evidence. So as somebody who's gone through the prison system for 26 years, interviewed thousands of people, worked hard to help more people understand what can you do to position yourself for best possible outcomes, as my partner Justin has done in coaching many people, helping them understand. We don't ever provide legal advice. We don't tell people what to do, but we do want you to understand the risks, the rewards, the opportunity costs that come with every single decision that you make. And that's one of the reasons that we produce so much free content for people to consider. We encourage you to listen to our podcast, the Prison Professors podcast, to get more of this insight. You also may want to subscribe to our YouTube channel because I'm publishing content every day. Here is the actual document that shows what the government's response to this issue is. I think I'm going to try to download it, and then I will publish it on our website if I can do so. I don't know if I can do so or not, but I'll do the best that I can to get this document on our website at let me see if I can sign up right now. I'll sign up with Michael, my website, michael@michaelsantos.com. That's my personal account. Does that download? Download the PDF. Yes, I want the PDF. And there it is. Excellent. So here's the actual document itself. We will go through this document and dissect this document. I can tell you right now that this document is 34 pages. This is the government's, is this the government, the United States of America versus David Cito et al. Defendants, government's response. So what we have here is the government's response to the allegations. And we're going to read how they talk about whatever their reasons are for avoiding this process. If you want this document without having to sign up, you can download it at prisonprofessors.com because we want you to see this information. You may be able to use it in calculating the best possible outcome for your decision. So you can probably slow this screen if you want to watch it here on the video. But this is the amount of work that goes into litigation. I can assure you that that the defense attorneys likely put in hundreds of hours, maybe 500-600 hours at a cost of $500 to $1,000 an hour to get this result, but it could result in their clients walking away. And I wish them the best of luck as they fight this very difficult battle against the U.S. government. And we encourage you to learn more from our videos and our podcast and the efforts we make to help people understand court, sentencing, and prison. If you want a free copy of our book, Prepare What Defendants Should Know Before Sentencing, Court, or Prison, you can download it from any of our websites that include whitecollaradvice.com, prisonprofessors.com, or resilientcourses.com. Those are different websites that we create for different purposes. And we hope that you find value in this. We'd love it if you subscribed to us on YouTube or on our iTunes podcast at Prison Professors. And if you want to reach out to us, you can do so by just sending an email to team@prisonprofessors.com. Thank you.